they're supposed to do to hold a hearing to decide whether or not they need to file an eminent domain case against you. It's a resolution of necessity. We hereby resolve that we can't agree with these people and we're going to have to take their property by eminent domain. You should get at least 15 days notice of that in writing. When you get that notice, you need to talk to somebody about it right away because you want to object, to them taking your property. And it's easy to do, but it's one of those traps that if you fail to object on time, you waive all those rights. And so again, it's easy to do, but it's also easy to waive. So you don't want to blow that. Now, let's assume the resolution of necessity is passed. They'll file a lawsuit. It'll be SDG&E versus Smith. If they're in a big hurry, which it sounds like they are, they often want to take possession of your property before the case is over. Before they even own it, they'll want to take possession of your property and start building. And there is a law that allows them to do that under certain circumstances. What they do is they make a deposit with the court of what they think they owe you, that based on their appraisal, okay? Then they get an order for possession of the property before the case is over, okay? You are entitled to withdraw that deposit without agreeing that that's the correct amount. So you can take the money out, use it for whatever you choose, without conceding anything, okay? Except the right to take, which I'll talk about in a minute. Then you can use that money to pay down the loan or to hire your appraisal or do whatever you want to do. About 6 months after the complaint gets filed, there's a scheduling conference where the judge will set a trial date. That typically happens about a year after the complaint. 90 days before the trial, the parties swap the appraisals. It's like a blind man, it's like trading hostages. You don't have to show them yours, and they don't have to show yours until 90 days. Then depositions of the experts get taken. That's when most of the negotiations occur. And if you don't agree to settle the case, then you can proceed to a jury trial. These trials typically take a week or two at the most, and then a jury fills in the blank. We hereby find the fair market value is X and severance damage is this. Then they pay you within 30 days, and you're done. Now, whether or not you want to go all the way to a jury trial, you don't need to decide that now. You can always waive rights later. What you want to do now is avoid giving anything away before you understand what you've got. Okay, so as long as it doesn't cost you any money to hang on, it's easy to do. You just say, no thank you. Get off my land. Now, as far as saying get off my land goes, there's been some controversy about whether they do have the right to come on private property without permission or a court order. Now, I'm going to try not to get too much into legalese tonight and split legal hairs. So let me start by telling you how it normally works as a practical matter. A condemning agency asks permission. A property owner says, no, I don't want you on my land. The agency goes back and goes into court and follows the normal procedures to get a court order. And then they come back with the court order, which is what Jody was asking for. Show me the authority for this. That's normally the way it's done, and it's normally what the government or the condemning agency wants to see done too, because it just allows for a more orderly process and nobody gets surprised. And they tell you we're going to come out on this date. This is the scope of the work we're doing. This is how long it's going to take, and you get insurance in case somebody gets hurt, and there's a bunch of legal procedures that you want to follow. But everybody knows what they're dealing with. What you want to avoid is multiple inspections by different people in unmarked vehicles driving around like they own the place. Now, I would suggest that you do not grant permission. I'd suggest you do that in writing. And I would say that you tell SDG&E, I don't want you on my land. And if you intend to seek a court order, I'd like to get notice of your request ahead of time so I can go in. Now, I want to be careful that nobody misunderstands what I'm saying tonight, though, because I don't want anybody to get hurt out there. I'm saying do not grant them permission. I'm not saying lay down in front of the bulldozer, okay, or square off with the burly surveyor, okay? You don't need to do that to protect your rights. Just tell them, no, then if they violate the law, you have a whole series of rights that you can pursue later. That is one of the reasons, or one example of why you want to do this stuff in writing. Because if a right-of-way agent is asking you these questions, do you mind if we go up there and dig around or bang on the dirt, and you say no, and then they bend over and write, he said okay under protest or something like that. And so there's really no upside, you know, to talking to them about that. Now, inverse condemnation. This comes into play more if your property is not physically being taken, but it's being injured somehow. I know there's a lot of businesses that have concerns about impacts. In theory, you may be able to recover for damage to your private property for a public project. In practice, there are many more obstacles to recovery in an inverse condemnation case than there are in a direct condemnation case. I'm not saying it can't happen. I'm saying it's an uphill battle, and it's very site-specific. So again, I would suggest if you have questions about that, come see me or somebody else on the list, and learn as much as you can about it as early as you can. Those are all of my remarks that I had planned tonight. But again, I'm open for questions here in an open meeting or after. Yes, sir.
When you mentioned a 15-day notice, what form is that notice to be done? And if someone was going to try to scam you by sending a day notice and you didn't actually receive it, what forms would that take? So we
normally
know
what they do, what normally happens is you receive a letter in the mail on SDG&E letterhead saying we intend to consider this resolution. It's in writing. Oftentimes, if they're being careful, there will be some sort of receipt, you know, some sort of proof that you were given it. So if you say I didn't get it or you sent it to the wrong address. Now, oftentimes they use the mailing address on the last tax roll. So you need to be careful to, you know, remember where your tax forms are going. Okay. But it should be in writing. Yes, ma'am.
On my mom's land, they've come on and surveyed, but they haven't. We locked the gate, and we never gave them permission. We asked them for permission. We said no. But they came in from neighbors' property on either side, and they put up surveys. What do we do about that? Do we write to them and say, don't come on anymore? I also saw a guy. He said he was looking for a bird. And I said, you need to leave. And he goes, oh, I'm looking for a certain bird. Probably won't find it anyways. And then he just kept walking. I said, you can't be here. You need to leave.
Well, if oftentimes these types of inspections are not going to be an isolated incident, but a steady stream of people coming through over weeks or months or years. And just the fact that they snuck over the fence one night doesn't mean that I'd do anything different than what I suggested earlier. So you write them a letter right now saying, I do not give you permission. You know, do not come on my land. And if you'd like, I could help you write something like that, a boilerplate letter that we could put together and maybe put it on the website so that everybody's on the same page. Yes?
Can you block the entrance? What I did initially.
Well, I'm not sure about that. You know, again, I'd be careful about what in the legal business we call self-help. You know, I mean, I don't want it to be the Wild West out there, where, you know, and I'm not suggesting we'd be soft on it. You know, what I would suggest is that you write the letter, you know, say, you know, stay off the land and give me notice if you intend to go to court. Now, one of the things that I wasn't sure I wanted to get into, but I talked about splitting hairs.